could have a presentation for us?
I'm smiling because there's a running challenge as to whether or not a lawyer can cover all the due processes in 10 to 15 minutes. So mark the clock and
16 till.
so let's see if it can be done. For those who have trouble seeing this, please feel free to move up close. For some of those too close, feel free to distance yourself from the attorney.
That's what they have.
Yeah, without invitation. The topic today is the due process. What I want to emphasize is the various different ways that we have of resolving all the different types of disputes that can arise in a managed care organization like ours. Typical, before I go through each of the processes, there's about 4 of them that I'm going to cover today. I wanted to cover some basic law 101 on some of this so you have perspective. For the lawyers on the board, feel free to chastise me privately off the record. The 14th Amendment provides in it that no state shall deprive any person of life, liberty, or property without due process of law. That applies to the states. It carries over from the 5th Amendment. Basic constitutional law tells us the elements are things that you have to have a government action, no state shall. You have to have a deprivation, and it has to be of life, liberty, or property. This is what a lot of times is referred to as entitlements. If you are entitled to something and that's being taken away from you, then you're entitled to due process. So that's kind of at the heart of a lot of the Medicaid and other types of appeals. What is due process? It's fundamentally notice that something is being done and an opportunity to be heard about it. Now, where it gets really interesting is how much detail. Is the notice before or after the action? Is the opportunity to be heard before or after the action? Is it done in front of a judge, in front of the organization making the decision, in front of a jury? Are you allowed to present evidence? Are you entitled to an attorney? All of those types of details will fill up volumes and do fill up volumes and volumes of law books. The bottom line is that how much notice and how much opportunity to be heard really depends on the entitlement and the circumstances. And there's been a lot of law in the area of managed care organizations and Medicaid that have kind of outlined what they offer us. So, but that's the thing to keep in mind is due process, what kind of notice and what type of opportunity to be heard. Another point on the overall law is that there's a lot, I mean a lot of controlling authorities that we need to comply with. I just mentioned the Constitution. We have to comply with all the federal and state statutes. That includes the Americans Disabilities Act, the Social Security Act, which actually the Medicaid Act is a subset of the Social Security Act. You guys have heard about the 1915 B and C waiver. Well, Section 1915 is in the Social Security Act and the Medicaid Act. There's a lot of famous cases. All of you have probably heard of the Olmstead case. It basically holds that consumers should be served in their homes and their communities-based services to the extent that it's feasible and can be done. This was originally done many years ago where there was a bad habit of institutionalizing individuals without an analysis of, well, geez, could services be provided to them in the community? So that's really at the heart of a lot of what we do. It's also at the heart of a lot of disputes that we still have to this day. You hear us talk about step downs. You hear us talk about lower levels of care. We're required by law to provide the lowest levels of care and the step downs because it's usually the highest level of integration with the community. We're doing our best to ensure that our consumers are having as much of a life in the entire community as is possible. Those are the broad strokes. We're required to comply with federal and state regulations. That's the North Carolina Administrative Code. The waiver is a type of regulation. Clinical coverage policies are passed by the Department of Health and Human Services, and they spell out the service definitions. There's a misconception out there that we actually do it, that we're like an insurance company that spells out our own insurance plans. That's not true. The state actually defines the service definitions for each of the various services that we offer. They're in the clinical coverage policies. Those are essentially anointed by the federal government through the waivers, and so we then have to comply with them. We have to comply with contracts. We have contracts with DMA, with DMH. We have contracts with all different providers. For those not familiar, DMA is the Medicaid side of DHHS, and DMH is the state side of DHHS. And then we have other things, some of which we've opted to do above and beyond the law. URAC is one of them. They are one of a few accrediting organizations that go in and they go to various parts of your organization and they verify that you are following certain quality control type mechanisms, have certain procedures in place. URAC requires that with our utilization management, with our call center, and with our provider network, thank you. Those 3 areas are URAC certified. And so what you will see as I talk today about some of the due processes, some of them are above and beyond the laws. They're things that we're required to do because of URAC, and they're even more robust. Bottom line, if nothing else you take away today, I say with confidence that we're in full compliance with all the due process. My goal is mostly to kind of assure you what those processes are, because you will hear from various folks, providers, consumers, fellow commissioners, fellow members of CFAC, other organizations about various things that they liked and didn't like. And one of the most important things is that everyone has an opportunity to be heard. They get a notice about the action being taken and an opportunity to say that we're wrong. And for us to truly hear that. And if not us, then move on to other forums. And so that's what I'll talk about today. So one of the things you need to often ask yourself when you hear about these is, did you get your due process? Did you get your opportunity to be heard? Hopefully, and in most instances, we have either been right or when we were wrong, we made changes. We're not perfect. I already kind of talked about the robust. Multi-door, we've made a great effort to ensure that there's no wrong way of really getting into these due processes. Or if you've knocked on the wrong door, we don't slam the door on you, we take it and funnel it to the right door. So I like to refer to it as a multi-door. All right, to the heart of the processes. There are essentially 4 dispute types, in my mind, that we have to deal with. 2 of them are consumer related, Medicaid appeals and non-Medicaid appeals. In the consumer-related ones, the entitlement I talked about, the deprivation of life, liberty, or property, is something that the consumer is entitled to. How much they're entitled to it, what the entitlement is, can vary. What you're entitled to through Medicaid versus what you're entitled to through state dollars, what you're entitled to through county dollars can vary. But on the Medicaid appeals, there's a certain process laid on out, and it deals with services that are denied, terminated, suspended, or reduced. So if we partially approve something, that's also a partial denial. There's a due process for that partial denial part. If we terminate, suspended, or reduced service that has already been authorized and hasn't expired, there's a process to deal with that. For non-Medicaid, there are consumer services that are funded by the state, county, and other sources, process for that. Third, there are provider disputes. TNOs are short for tentative notices of overpayment. They're called tentative because overpayments are not final until either a certain number of days have gone by and they haven't appealed, they haven't exercised their due process, or within that time period, I believe it's 30 days, they have appealed, it goes through the process and it's still upheld. So overpayments, or sometimes you hear them called paybacks. It's situations where we have gone ahead and made payments for services that were rendered and it turned out the documents weren't there, the services really weren't rendered, or whatever the circumstances require. Terminations, we have a closed network of providers. We're very careful, as we were talking about, trying to incentivize the right providers for the right parts of our network. So we have those, on occasion, we're having to terminate providers for cause, without cause, depending on circumstances. They have a due process. And then relatives as direct support employees, you've heard a lot about that. Ms. Short talked a little bit about it today. They are actually employees of the provider, and the provider actually has an entitlement to determine who to hire and who not to hire. And so that appeal process goes through the provider disputes, and we'll talk more about that in a moment. And then lastly, grievances. Grievances is a catch-all. If you don't have a consumer appeal right through Medicaid or non-Medicaid, if you don't have a provider dispute right through that process, if you're not a consumer or a provider, and you still got a complaint, our grass is too tall, you came visiting and were treated rudely, any type of concerns, you can do it through the grievance process, and we'll talk a little bit more about that. So those are the 4 processes. Let's talk first about consumer Medicaid appeals and actions. They're called actions, which is a term of art. Basically, under the federal regulations, if it's a denial, termination, reduction, or suspension of the enrollee, recipient, consumer services, then it is an action. The reason why that's important is if it's not an action, then it's a grievance. Under Medicaid law, those are the two categories. You either have an action, and if it ain't, then it's a grievance. And if you have an action, it's a much more robust process because it's affecting your services. It's a much more serious entitlement that's being deprived. Tip: if you hear folks talking to you about appeals, reconsiderations, complaints, grievances, resolutions, reviews, disputes, mediation, decisions, recommendations, adverse determinations, and this is just a partial list, there's a very good chance, even if they're an attorney, that they are using it wrong. Because those terms are muddled up in the state law and the federal law. I won't go through a whole lot of it. There's things like what we call reconsideration at the state level is called an appeal at the federal level. What we call an appeal at the state level is called a state fair hearing at the federal level. It gets confusing. So the tip for you is, as you hear folks say, I didn't get a right to do an appeal or something like that, is to really delve in, if you're interested, to find out, well, what exactly was involved and what did you get? Because they may be using the words inappropriately, but the substance is right. With the consumer Medicaid appeals or actions, again, we already talked about services denied, suspended. For each of these four, I've kind of created an up-step process that shows you. The very first thing in a consumer Medicaid appeal is a decision letter goes out, usually called a notice of decision. They may start calling them notices of action because of that federal language. As soon as, and that goes out to both the consumer and the provider, so that everybody knows. In fact, the providers find out a little quicker because they've got an electronic portal that they can access and see, whereas we send it by mail to the consumers. Either one of them, hopefully they talk to each other about it. The denials are based on, the decisions are based on documentation for medical necessity. To keep the slides small, I have MN in there. But that's medical necessity per the state and federal standards I talked about earlier, the clinical coverage policies. 5 days, within about 5 days of receiving or sending of the notice of decision, you can do a peer-to-peer. This is something that's not required by law. This is something that we've incorporated largely through URAC and other procedures. That's why you'll notice I have a dark blue on a lot of things, but this is a light blue because it's optional. A peer-to-peer is basically your doctor talk to our doctor, your clinician talk to our clinician. Let's just get on the phone and find out. Because it could be an assessment's missing, a document's missing, or there's a misunderstanding as to what the definitions require. This is not used as much as we'd like, and we're working hard on trying to get more and more folks to do it because we've gotten really good results from it by just having the subject matter experts talk to each other. In fact, one of the things I discovered recently when I was at a DSS and attorney conference, county attorney conference, is that a lot of them didn't realize it existed. And it's empowering and telling the consumers and the guardians and the others to call up their provider and say, get on the horn and talk. There's a peer-to-peer process. Take advantage of it. There's, I don't have the percentages, but I've heard there's a very low number that actually, even when we reach out, excuse me? 17% that actually take advantage of it. And they're very successful. So, timing, process details are heavily governed. To keep this moving along, I'm not going to go into all the timing, but each of these, generally by federal or state law or by URAC standards, you have to get letters out in certain time periods, you have to do various things in certain time periods. There's then an independent reconsideration. If the consumer is unhappy with a decision, they ask for independent reconsideration, which is another clinician who comes in, looks at the same documents, uninvolved in all the previous matters, and they go ahead and they make their own independent decision. Once that is done, you'll notice all of these are in blue. That's because all of these have been done internally, including the independent reconsideration, even though it's farmed out sometimes to a vendor. It's still us reconsidering our own decision. So we're going through this whole process of, we made a decision, are we going to stick to our decision? We say yes, at which point the consumer now has a right to go to the Office of Administrative Hearings, OAH, with an administrative law judge, and present all their evidence as to why we're wrong. In fact, there's a new evidence rule, it's called new evidence rule, to where if something new has happened between when we made our decision and that hearing, they can still present it. Because the concept isn't who's right or wrong. The concept is the consumer getting the services they need at that point in time. So right up to the day of the hearings, we're sometimes getting the assessment we've been asking for all along. Or something happened to the consumer and they've got a medical issue that complicates things and now suddenly the service becomes appropriate. There's a mediation process within 10 to 25 days after they do this that allows them to take advantage of the mediation. Not all of them do. I think only about 33% of them actually go to mediation, but we have a very high resolution rate at that. Again, a lot of this, in my opinion, is miscommunications. Folks don't realize there's other services available, or all we need is certain documents. One more opportunity to actually discuss it. If they're unhappy with the resolution from OAH, they then enter, after all this, they then enter the judicial system. They can go to the Superior Court, they can go to the North Carolina Court of Appeals, they can go all the way up to the state Supreme Court, arguing all of these particular matters. That's essentially the consumer Medicaid approach. That is very similar to the consumer non-Medicaid appeals. Again, this is state, county, and other funds. These are considered more discretionary funds. When we talk about entitlements, these are discretionary. It has been held by law that we have a lot more control and discretion as to how these funds are used, and as a result, the process is a little less formal, and the final decision is actually made by the LME, but it does have an outside touch. The first three steps are the exact same ones I described. Again, by law, we don't necessarily have to do it, but we think for an abundance of being heard and getting noticed, we think they're very good to use on the state side as well. It also provides a little seamlessness, so we follow that as well. Then, instead of going to OAH, the Office of Administrative Hearings, which is part of the state executive branch, we go to the DMH, which is the state arm of DHHS, and they have a hearing officer, and she hears it. And it's very similar to OAH, in some ways different. With OAH, they're almost always by telephone. In DMH, they actually have a hearing officer. She's a JD with a master's in social work, I believe, who goes all around the state hearing these. And she actually shows up in person in the catchment area, so everyone's together in the room, which again is another great opportunity to meet face to face and make sure this isn't just a communication problem. The DMH hearing officer issues a decision, but it's actually really a recommendation. Because the final decision stays with the LME, that decision is then given to the CEO or the area authority director, who then issues a final decision. That final decision can agree with or disagree with, or partially agree or partially disagree with whatever the DMH hearing officer had determined. In every single instance so far where things have gone that far, our CEO has agreed with the DMH hearing officer. We may have expanded on some language or clarified some things, but in every single instance, whatever the decision was by DMH, we've gone along with also. Third process, provider appeals. These are getting much more complex these days, so I've tried to get it down really short. As I said, paybacks, terminations. These are not consumer services. The consumer services have already been approved, so that's not being involved here. This is not also involving which employee gets to do it, or relative as direct support employee getting to do it. This has to do with the provider itself. The provider is enrolled in the Medicaid program. The provider has contract requirements. They've gone through credentialing requirements, and something goes wrong. We've either overpaid them for whatever reason because they don't have the documentations or whatever, so we're asking for money back, or we've terminated them, those types of things. So we give them those notices. They then get a level 1 or level 2 panel. Level 1 and level 2 if they want both. Or they just get an administrative investigation. Essentially what happens is, it's just an administrative matter. If it's a matter about overpayments and documentation, that's generally handled by a staffer internally who issues a decision letter. If, however, it involves clinical problems or a status in the network, for example, you're being terminated or something like that, or certain services you're doing are being terminated but not others, then you get to have a level 1 panel appeal. That panel is a mix of our staff and outside providers and clinicians in the same area specialty. So you're actually, I should probably almost put a little purple on this one because it's a mix of both us and the outside world reviewing that. If you're unhappy with the level 1 panel comes up with, then you get to have a second panel of all new people, starts from scratch, and you get to see it again. Again, this is not required by law. This is something we largely do through your act. It's above and beyond, and so you won't see this in all MCOs. If you're unhappy with that, then you can go to OAH. There's a legal debate going on throughout the state as to whether everything can go to OAH by the provider or only certain things. I won't bore you with that, but the gist of it is that a lot of them do wind up going to OAH, an administrative law judge. There is a mediation process, there is a hearing, and they do issue a final decision. That final decision represents the final decision on behalf of the state. If they're unhappy with that, they can go through the courts and the judicial system. Grievances, this is just basically the same thing I mentioned earlier. Grievance is everything that is not an action. The confusion is that under federal law, and they even admit it, the overall system is called a grievance system. So appeals and actions are in a grievance system. Again, all you need to do for a takeaway is remember that if they say grievance, if they say appeal, if they say action, they may or may not be using it appropriately. Find out exactly what is going on. And of course, refer them to us. Grievances. All staff are trained to take in grievances. That's one of the very important things. When we onboard folks on a regular basis, we make sure, again, this is the multi-door. It doesn't matter who you call on up, we can take in that grievance. Remember, it can be anyone on almost any subject. The grievance is lodged. Whoever takes it in, puts it into the computer system. We have people responsible then for making sure that grievance is properly vetted through the system. They acknowledge it with a letter, usually within 5 days, to whoever it is. It's often a consumer, but it can be consumer, provider, anybody. We acknowledge it with a letter. It is assigned to the appropriate person or people within our organization. If it deals with providers, it's probably going to be somebody on the provider network. If it's going to be consumers, it's probably somebody on consumer relations. If it's rudeness by an employee, it may well be HR. It just depends on the nature of the grievance. There's an investigation done and a decision made and a letter is issued. And all of this is done on a strict timeline set by laws and regulations. We then have another panel review like we do with some of the others. This one I did wisely put a little purple around the blue because it's a mix. The panel is both staff plus Consumer and Human Rights Committee members. So that again, while it's still internal, we're still deciding on our own whether we've done the right thing or the wrong thing. We're bringing in outsiders to help us make that decision and keep us on the right course. And then finally, the panel review issues their recommendation to the CEO, who then issues a final decision. Much like we do with the DMH hearings, we have yet to have a situation where the panel said one thing and the CEO said another. It's basically whatever they decide, reduced to writing, sent out in a letter, and sent to the consumer. The one thing that is a little bit different is by state law for grievances, that's the end of the process. They can call DMH, they can call DMA, and they can complain, and the state, as our overseers, can call us on up and say what's going on. But as far as a formal appeal or grievance process, that's the end of the line. Those are the 4 processes. I had on your questions, but I did not make the timeline, so I retract the question off. I am available, though, to talk to folks offline later about any of this. But it was so exciting, you didn't notice I was over time, right?
Depends on who you are.
Ask questions.
See if that was right.
Thank you, Mr. Love, for that enlightening presentation. I don't know why I determined the presentation was there.
Give me a timeline, I'll just go fast.
Are they not going to ask any
All right, moving
questions?
down to item number B.
Wow.
I did point out that we have new appointments for the Finance Committee for the 14-15 year. Barbara Anderson from Surrey County, Ken Petit for Gaston County, and Frank Zachary for Yadkin County. Appreciate those people serving on Finance Committee. I think it is a total of 7 members on that committee. Do a good job for us. Also, I think you were passed out, you've got a list of those committees. Each of them.